Something that I'm asked quite frequently by clients is whether they own a share in their property with their partner, and if they were to pass away, what would happen. So it's really important from the off that you understand how you own your property with your partner, if at all. And what would be a clear indication is whether there is a land registry title with both of your names, whether you have a declaration of trust in place, whether you have a cohabitation agreement in place, various different mechanisms to understand how much you would potentially have in a property in terms of shares, or whether you own it 100% equal with your partner. Now, depending on the way that you own the property, either joint tenants or tenants in common will depend on whether you receive a share if your partner was to pass away. So joint tenants, it would automatically apply to you and you would receive it regardless of any wills or rules of intestacy. For tenants in common, it is slightly different. It's in respect of defined shares. Now, if your partner hasn't named you as a beneficiary within their will, or it's not or, it's if they haven't, can I just kind of start that sentence again? If your partner hasn't named you as a beneficiary within their will, then it would fall to the rules of intestacy if they don't have a will in place. And unfortunately, unmarried persons aren't a category within the intestacy rules, and so you wouldn't automatically receive it. And there could potentially be contested arguments that you could raise, and you should seek independent legal advice about that. But it's really important from the off that if you both are in agreement that you would like each other to receive a share, but you want to make sure that you're protected if you were to separate, that you do get some legal advice about potential declarations of trust or cohabitation agreements, because that's really important to have in place to best protect both of you in the event of a death or a separation.